Ladies and gentlemen, today we are going to talk about two very important theories in the field of public international law. These two theories form the underlying basis upon which the states enter into various treaties or agreements. These two theories are the theory of consent and the theory of consensus. The theory of consent is also known as the auto-limitation theory or the self-limitation theory. We'll be discussing these theories and we'll also be discussing their criticisms. So let us first start with the consent theory. What is the meaning of consent? First, let us discuss the dictionary meaning. Black's Law Dictionary defines consent as agreement, approval, or permission as to some act or purpose when given voluntarily by a competent person. It also means a legally effective assent. So this is a self-explanatory meaning, and all of you know that consent is always voluntary in nature. And when we talk about states, we mean that when the state gives its assent for doing or not doing something. The founder of this theory is George Jelinek. He also calls this theory as the theory of auto-limitation because the crux of this theory lies in the self-limitation of the will of the state. You must be asking that what is the meaning of will of the state? If you have studied jurisprudence, then you must be knowing that every legal person has a will of its own. This is a basic presumption that is made in the field of law. In the same way, state also has a will of its own. So, when the state self-limits its will, when the state restricts its will in a limited sense, then it is called as self-limitation of the will of the state. And the purpose of this theory was to place international law on an equal footing to national or domestic law. Because if we see national or domestic law, these laws are framed by the competent legislatures and they are framed only when the legislative members or the legislative representatives give their consent to passing of a certain law. In the same way, the consent theory espouses that the state must give its consent in order to become a member of a treaty or an agreement or in order to follow a particular norm of international law. I would also like to quote Malcolm Shaw here. He says that the states could only be obliged to comply with international legal rules if they had first agreed to be so obliged. Basically, the states must agree to apply a particular international law on them. If they do not agree, that law may not be applicable on them. This theory was also discussed in the very famous SS Lotus case. We'll be discussing these cases in detail in our later episodes. In the SS Lotus case, it was held that the rules of law binding upon states emanate from their own free will as expressed in treaties or by usage. So, if a country has acceded to a particular treaty or instrument, it means that the instrument or the treaty contains the free will of the state. Whatever is written in that treaty expresses the free will of the state. Even though this theory may sound very lucrative and even though you might be thinking that it is not possible for any state to enter into a treaty without consent, yet there are some very pertinent criticisms of consent theory. There are three main criticisms that I would like to discuss. First is that it fails to explain why international law is regarded as binding. Even though a country has given its consent, still why that international norm or why that international rule should be binding on a particular country is something that this theory fails to explain. It also fails to take into account the growth that has taken place in international institutions, rules, and regulations. today we are living in a very complex world. We are living in a digital and technological world. The rules of the games are changing every day. Every day some new technology is coming up. Every day some country is changing its requirement based upon those technologies. Every day those new changes are affecting the economics and finance of a country. So the rapid growth that is taking place in the global diaspora today has not been taken into account by the consent theory, and that is why this consent theory is considered as an older theory. The new theory that has been gaining traction is the consensus theory. The last criticism of the consent theory is that what if a country withdraws its consent? What would be the consequence? This is something that has not been dealt with by this consent theory. It only says that if a country has given its consent, then that particular international law or rule would be binding on it. Breach of agreement leads to violation of international law. That is a settled principle. Many of you might have heard the Latin phrase pacta sunt servanda, which means that treaties must be abided in good faith. So if there is any violation of any agreement, then what would be its consequence? If its consequence has been provided in that treaty, then that particular course will take place. However, if that consequence has not been provided in that treaty, then what would be the end result? It is something that the consent theory has failed to provide. So that is all about the consent theory. Now let us come to the consensus theory or the doctrine of consensus. What is the meaning of consensus? Literally, it means a general agreement or a collective opinion. Basically, it is an attempt to achieve an agreement of all the participants in a multilateral forum without any objection. Suppose there are 10 countries and their representatives are sitting together, and there is some agenda that is to be discussed. Now, if all the 10 countries agree on that particular agenda, then we could say that there is consensus. However, if 2 out of those 10 countries are not agreeing on that particular agenda, then it means that consensus has not been achieved. The formal definition of consensus has also been provided in Article 161 of UN Convention on Law of Sea. It defines consensus as absence of any formal objection. So if there is no objection, if everybody is on board, if everybody is agreeing, that means there is consensus. Now, we also need to understand that consensus may be of two types, active or passive. Active consensus simply means right to agree as well as disagree with the outcome of a particular meeting or conference or a particular forum. Whereas passive consensus means trusting in the desire for a successful outcome so as to expeditiously reach a compromise. Suppose 5 countries are sitting together on a table. Now there is one country that is not sure about its stand upon a particular agenda. So it might keep itself silent. It might not speak on the issue. It might see that what others are saying, what are the views of other countries, and it might say that whatever is the view of others, we will agree to that. So if that is the methodology that is followed, then it would be said that there is passive consensus of that country. You would be surprised to know that consensus theory is gaining more and more traction day by day, and it represents the current trend. Earlier theorists had posed their faith in the consent theory. They believed that consent is the all and end all of all that is comprised in international law. However, consensus is very important as it reflects the influence of the majority in creation of new norms of international law and acceptance of such new rules by other states who may not be in majority. So, can it be said that consent does not play any role in international law? No, consent still plays a very important role in the domain of international law, as states expressly agree to specific normative standards by entering into various agreements or treaties. And each state has the right to seek to influence by word or deed the development of specific rules of international law. However, you should also remember that creation of new customary rules is not dependent upon the express consent of each particular state. What do we mean by this? Suppose there is a agreement that has been entered into by 10 countries. Now those 10 countries have to sit together and decide on particular agendas. Suppose on one of the agendas 3 out of 10 countries do not agree, but 7 countries agree and 7 forms the majority. So if the agreement is providing that decisions will be taken on the basis of majority, then the majority opinion would prevail upon the minority. So creation of new customary rules is not dependent upon express consent of each particular state. This also leads us to think that can there ever be a separation of law and politics in international law? Because consensus and consent, they are all about politics. They are political instruments. They are political tools that are used by countries. This is also important to understand because in domestic systems, interference with judicial process is regarded as an attack on law, and there is a strict separation of legislature, executive, and judiciary. However, in the field of international law, the states are responsible for both making of the law and for interpreting and enforcing them. Thus, politics operates more closely with law in international system than the domestic systems. And this is mainly because of these two theories of international law, that is the consensus theory and the consent theory. I hope I have been able to explain these theories in brief to all of you. If you want me to explain these theories in more detail, please let me know in the comments. And please subscribe me. Please do not forget to subscribe this channel. If you will subscribe, I'll be able to make more content. I'll be able to give you more quality. Thank you for watching. I'll see you in the next episode.